Maintenance aims to cover the elementary needs of private persons. Therefore, it is very important that such obligations are in fact met. Maintenance recovery often affects women with single parents, mothers, and children particularly affected. It often occurs in cases involving the separation or divorce of parents. Children, as the most vulnerable group of creditors, generally do not have their own income and cannot organize recovery themselves. In cross-border cases, difficulties often arise. Maintenance recovery often involves an intricate and lengthy multi-step process of conflict resolution. From the very onset of this process, there arise problems of access to the competent authorities and institutions. Despite the fact that cross-border maintenance recovery is widely regulated by the European Regulation on Maintenance of 2008 and the Hague Maintenance Protocol of 2007, maintenance recovery is still a complicated and difficult field. Therefore, it is not only international and European regulations for child maintenance that are of extreme importance, but also practical assistance efforts. There are central authorities in every member state which are expected to work effectively and communicate with each other and the parties. There are also some non-governmental organizations active in this field. The applicable maintenance law is in general that of the habitual residence of the maintenance creditor. However, substantive maintenance law as such has not been unified in Europe, and individual cases involving different circumstances require individual treatment. National legal rules and organizational structures are different, and often there is insufficient assistance, beginning already with problems of translation and the obtaining of legal aid. Against the background of the project questionnaire, the efficiency of the different recovery methods has been examined. In maintenance recovery, there are three main groups of cases. Direct claims may arise if spousal or child support has not previously been fixed. Then the claimant himself, with or without the assistance of a lawyer or a public body, attempts to pursue his maintenance claim. Such claims encounter an array of problems. It may start with a problem which is as mundane as it is crucial: how to locate the obligated person if its whereabouts are not known. A second case group relates to maintenance on the basis of an already existing maintenance title. If there is a foreign decision, question of recognition and enforcement have to be resolved. On the basis of the maintenance regulation, in most cases, an exequatur for the foreign decision is no longer a prerequisite. However, it may also be necessary to make modification to an already existing foreign maintenance decision when there are changes in the parents' or children's circumstances. A third category, recovery by public bodies, does not concern private creditors directly. Here, the national public body tries to obtain reimbursement in another country from the debtor, such as in cases where there were advance payments of maintenance. Information available on the internet has to be understandable for professionals and, as far as possible, the needy persons themselves. Hints as to which persons and institutions can provide assistance are necessary. Today, much of the existing information seemingly does not reach the general public. The EU's provision of better structured information, assisting national authorities, and internet pages describing the individual stages of maintenance recovery are needed. Training of professionals should be intensified. The additional European platform for access to personal and family rights will give better access to legal information and advice in the field of maintenance. The new platform will be a major improvement in dealing with maintenance obligations and maintenance recovery.